Hello, my name is Dale O'Neill. I'm a lawyer in Fort Worth, Texas, and today I want to talk to you about Texas divorces and federal taxes. I'm board certified in family law by the State Bar of Texas, and I've got an LLM in taxation, and I'm licensed to practice in the United States Federal Tax Court in all 50 states. My personal practice areas are tax controversy, people that owe the IRS a lot of money, and I do a lot of co-counsel with divorce lawyers throughout the state of Texas. I work with divorce lawyers whose clients owe a lot of money in taxes or have tax implications in their divorce strategies and the divorce settlement. And I help people all throughout the United States with all sorts of tax controversies. Now, in today's message, today's video, we're going to talk about Texas divorces and federal taxes. And there are 5 big topics that we're going to focus on. The first is unpaid 941 taxes and your personal responsibility, your personal liability. The second is the sale of a personal residence complicated by a divorce. The third is filing income taxes while you're separated or while you're in the middle of a divorce. The fourth is getting copies of your IRS tax transcripts. And the fifth and last is the innocent spouse relief given to people by the IRS. People who owe a significant amount of money to taxes, the IRS can sometimes get innocent spouse relief. Now we're going to begin with these unpaid 941 taxes. And let me give you a little oversight about 941 taxes. Some people call those employer taxes or employee taxes. 941 is the section of the IRS code that says, it mandates, that an employer must withhold a certain amount of taxes from the employee's paycheck. Then they match it and they remit that to the IRS. That's section 941 of the IRS code. Well, typically the employer that's withholding the money is a corporation, an LLC, or a partnership, some sort of entity, and they're withholding it from an individual taxpayer, an employee, and remitting it to the IRS. And so usually the liability to remit that money falls upon the employer, the LLC, the corporation, the partnership. However, and this can get real important in the middle of a divorce, the IRS has a provision in the IRS code that says an individual, a person, can be liable if that money is not remitted properly and timely to the IRS. In fact, it's section 6672, and I'm just going to read it, and I believe it's going to be on the screen. Internal Revenue Code section 6672 provides that any individual, so not a corporation, an individual who's required to collect, truthfully account for, and pay over payroll tax for an LLC or corporation who willfully fails to do so shall be personally liable for the amount due, including penalties and interest. And you may be thinking, well, this is a long way from a divorce, and I will tell you, I see this every day in divorces. An individual can be responsible if they fall into any one of these categories. They can be an officer and employee of the corporation, a partner or employee of a partnership, a member or employee of an LLC, a corporate director or shareholder, another corporation, a surety, a lender, a payroll service provider, anybody who's responsible for handling the payroll or human resources in any event. And so when the IRS talks about an employee, that's virtually everyone that works there can be held personally liable. And the standard they use is if you're a high-level person, a shareholder or a director, or if you're any person who's actually in the bookkeeping department, they can come after you personally. And when I say personally, that means that they can sue you. They can garnish your wages. They can file a lien against you personally. So if and I saw this exact example once. There was a lady who was a volunteer at her church, and she handled payroll and did not get paid. And the 941 taxes that were owing over $100,000. And the IRS sued her, got a judgment against her, and filed a lien against her for over $100,000. That's a real live story about these unpaid 941 taxes. The official name is called Trust Fund Recovery Penalty. It's important to understand that there's a big difference in these 941 taxes for the amount withheld from the employee's paycheck and the amount matched. Under federal law, the amount withheld from the employee's paycheck, that's the amount that someone can be personally responsible for. So they've taken that money from an employee. They're supposed to hold it and then remit it to the IRS. Well, they've taken that money from the employee, but they didn't remit it to the IRS. They were supposed to hold that in trust for the benefit of that employee and remit it to the IRS. They didn't. And the importance of these 941 taxes, it's hard to explain. These 941 taxes that are collected by employers account for over 70% of the United States federal budget. It's so important to the running of the United States, the government, that the IRS has created a special division within the IRS called the Trust Fund Recovery Division. And they aggressively go after people. They aggressively make people personally liable for these taxes that have been withheld. And I know you're thinking right now, what in the world has this got to do with divorce? And I'm going to tell you what it's got to do with divorce. A lot of companies are owned by mom and pop, small business owners. They go through life, they're happily married, they create a business, they've got an ongoing business, it's going fine, and something happens. They stub their toe, they get a divorce, it just doesn't work, etc. And what I see every day of my professional career is a wife or an ex-wife coming into me. She's holding in her hand a letter from the IRS, and she's got tears in her eyes, and she says, I don't understand this. I got a letter concerning a business that was awarded to my husband in the divorce. I'm not associated with it in any way. And it says here I owe $300,000. And it's addressed to me personally. What's going on? Well, I look at the letter, I look at her divorce decree, I dig through the files, and do a little investigation, and what's happened is the parties got a divorce. There wasn't a formal investigation done as to the payment of the 941 taxes by the business. In the classic example, the husband got that business, and it says something in the decree like, and he's responsible for all tax payments and debts associated with the business, and she gets the house. And they all assume that the business was worth, let's just say $500,000, and the house had $500,000 in equity. They all assumed that he was timely paying the 941 taxes in the middle of the divorce, before the divorce, and after the divorce. And he's not. Now the business is defunct, and she thinks at least she got the house with $500,000 equity. She has this letter in her hand now and tears in her eyes, and she's about to be told, the IRS is coming after you personally. And that's when you have to present a defense. No, IRS, this lady was not personally involved in this business, and we have to factually show them credible evidence, witnesses, documents, etc., that she did not participate in the active management of that business. Because if we cannot prove it, and the IRS can hold her personally responsible, then that house that she got in a divorce that she thinks is hers and clear and $500,000 equity, the IRS can file a lien against it. Her job, where she works as a teacher making $50,000 a year, the IRS can garnish her wages. So when she exited her divorce, she had a plan. She had a house, she had a job, she was free, and she thought that she was okay. And with that one letter from the IRS, because some lawyer in the divorce didn't do a proper investigation, she's now about to lose everything, including her income. What we do in our office, we try to do an investigation before the divorce is granted to make sure that those 941 taxes are current. There's a couple of different ways to do it. You can review the transcripts, which we'll talk about later, or you can actually look at the books and see if they're canceled checks paid payable to the IRS that match the 941 quarterlies and 940s end of year, to make sure all those things correlate and mesh together and make sure all payments are made. So 941 taxes are a big, big deal for a party going through a divorce if they have a business. The next thing I'd like to talk about, we're talking about federal taxes and Texas divorces, is sale of your residence when you sell your house. And if you take a deep breath and think about it, A lot of people, when they get a divorce, they sell their house. They raise their kids, they live together, house is too big, it's got bad memories. Part of the divorce agreement is we're going to sell the house. The lawyer tells the divorce client, well, you don't have to worry about that. You don't have to pay taxes on those gains. And that's technically true. It doesn't tell the whole story, but it's technically true. And in fact, the IRS Section 121 says that if it's your primary residence, and it's a proof issue, if it's your primary residence and you've resided in it at least 2 of the previous 5 years, then a joint couple, can exclude the first $500,000 of gain, and an individual can exclude the first $250,000 of gain. And so what everybody does going through divorce in today's world, they Google everything they can find about how to divide assets, and et cetera, and who gets the tax dependency on children, and they Google everything they find, and they see this thing on Google. Or the lawyer tells them in passing, you don't have to pay tax on that. It's tax-free. It's tax-exempt. And what I see happen, and it's a tragic story, I'll give you the classic example, the scenario that I see on a regular basis. 2 good people. They got married. In our example, they bought a house 5 or 6 years ago. In our example, let's say they paid $900,000 for it. They put $100,000 down and they owe $800,000. Things don't work out. There's a bump in the road. They get a divorce and they decide, we're going to sell this house and divide the equity. They put the house up for sale. They sell it. And by the time they pay off the mortgage, the realtor, the closing costs, the property taxes, everything else, it's sold and they get no money. Neither one of them gets any money. They're not harmed. They just paid off the mortgage, et cetera, et cetera. So they go to the title company. They go to closing. They sign all the papers. All the papers are done. They leave with no money. What they don't know is that title company has a legal obligation under federal law to issue a 1099. And what the title company does under federal law, they issue a 1099 for the sales transaction amount. In our example, $900,000. And if you take a deep breath and think it through, when people get a divorce and they sell a house, they no longer live at that house. So they leave, and let's just say in our example, in the spring of the year, they leave, they've sold their house, they got a divorce, and they're starting a new life. And that's the way they feel about life. They are starting a new life. And what they don't realize is December 31st, 9 months later, that title company is going to issue a 1099. And that title company has no idea where to mail it. These people are divorced now. They've moved. They've retired. They've got somebody new in their life. And so what that title company does under federal law, they mail that 1099 to the last known address. And so that 1099 shows up to the new owners. I mean, they bought this house. They had that transaction with the sellers. They know them. They see this copy and think, well, yeah, I mean, that's a done deal. We did all that, and they don't think anything about it, and they usually toss it in the trash because that transaction has been completed. And so that divorced couple who have sold their house and got no money out of it, there's a 1099 floating around out there for each of them for $900,000. And they don't know it. They have absolutely no idea because they've Googled, a divorce lawyer has told them, the gains on that house are tax-free. They're exempt. You don't have to pay taxes on it. And so they assume, like most people, well, if I don't have to pay taxes on it, I don't need to deal with that. That's not an issue. The lawyer told me it's tax-free. But what really happens is eventually, with a cycle of time, when they file their next income tax return, that's when the IRS learns where they're living now. When they file their next income tax return and they're expecting a refund, doesn't matter if the refund's $200 or $2,000, and the letter comes to the IRS and they think it's their refund and they run out thinking, oh man, we're gonna have some money now. But it's not. a refund, and in fact, it's a letter from the IRS. And I'm not embellishing. That letter would typically say you owe $400,000. Well, how can this be? How can I don't owe any money. The lawyer told me it's tax-free. It's tax-exempt. This letter says I owe $400,000. Well, wait a minute. We went to the title company and got nothing. How could I owe anything? In between the lawyer, the Google, closing, no money, how could I owe anything? And what happens is, when that title company sends that 1099 to the IRS, that's all the information that the IRS has. And under federal law, when the IRS gets that 1099, they assume that there was a transaction of $900,000 and that the party, the recipient of that 1099, the seller, got $900,000. Because that 1099 doesn't have any other information like basis or realtor's fees or closing costs or how much you spent fixing it up or rehabbing it or putting a new fence up. It's just got one line, $900,000, with the recipient's name and their social security number. And so people come into me with this letter saying, I owe $400,000. How can this possibly be? And what happens is they never reflected any of it. They didn't put the transaction at all on their income tax return. And so the IRS got this information from a third party, from a title company. They presume it to be true. They believe there's a $900,000 profit because they don't know anything about the basis, how much was paid for the house, and therefore they just do their own math. And so how can you think, Dale, how can we owe $400,000? We didn't get any money, and the whole deal was $900,000. That's, how can that be? Those numbers don't add up. Well, if it was $900,000 and the IRS presumes it's just ordinary income, they don't know it's a long-term capital gain, they don't know it's a basis, they take that entire $900,000 and just assume it's ordinary income, and you owe 38% on it. Okay, that doesn't get you to $400,000. Well, then there's a penalty. Penalty for what? Underreporting. You underreported $900,000. There's a penalty for accuracy. There's a penalty for all these things. And then there's this interest since you sold it, since you should have reported on your income tax return. And so that money that you got nothing for, you now owe $400,000. And so for that reason, lawyer, anytime you handle a divorce with clients who are going to sell a house, I recommend you put the following language either in a CYA letter or in the MSA or even in the decree of divorce itself. You need to tell these folks, I've got A, B, C, D, and E. A, the parties are expressly ordered to cooperate in the exchange of information regarding any of all taxes for the last tax year. That includes the exchange of any and all 1099s, etc. B, this is important, parties to cooperate on Schedule D relating to the sale of the residence. Next, parties to cooperate on completing IRS Publication 523 and the 3 IRS 523 worksheets. If you're not familiar with it, the 523 worksheet shows how much did we pay for it, what did we get, when did we get it. Then it shows when did we sell it, how much did we get for it. And between those two, we can compute how much is the gain. Then the parties to cooperate on IRS Form 8949. And between all of those documents, it should be that it's going to be tax exempt. And if they'd have done it that way the first time, they wouldn't have had to hire me, and they wouldn't have had to get a letter for the $400,000, and they would have received their initial refund that they thought they were going to get some time ago. But doing these things will make things a lot better for both you and your client. The other thing I sometimes throw in there, going to sell their house, go ahead and tell them to do an IRS change of address form. That way, when the divorce is over and the dust is settled and they know they're going to relocate anyway, the first person they really ought to tell is the IRS, because there's going to be a lot of paperwork involved with divorcing parties, exchanging information, 1099s, W-2s, write-offs, etc., etc. If you'll do those things for your client, that will help them enormously dealing with the IRS or avoiding the IRS relating to the sale of a residence incident to divorce. The next thing I'd like to talk about, filing income tax returns while you're separated. Most CPAs, not everyone, most CPAs will tell a potential client, I'm sorry, if you're married in a community property state like Texas, doesn't matter if you're separated, you've got to file a married filing separately or a joint income tax return. And if you file a married filing separate income tax return, you must declare 1/2 of your income and 1/2 of your spouse's income, your estranged spouse. And a lot of people say, well, I haven't seen him in 16 months. And the IRS, the CPA will say, that's what the IRS requires because you're in a community property state. I will tell you, I don't believe that to be true. I'm going to specifically refer you to IRS Publications 504 and IRS Publication 555. Between those two documents, there is a map, a framework of exactly how you can file either married filing separately or head of household and even get a better tax advantage if you meet certain criteria. So if you're in the middle of a divorce, or you can't find your spouse, they're estranged from you, you don't want to deal with them, they won't give you their tax documents, they're trying to hide that information from you anyway, they're trying to hide from you anyway, and you go to your CPA and say, what do I do? Well, the short answer is that CPA needs to read Publication 504 and 555 and emerge from that and determine if you meet the criteria for either filing separately or head of household. And if you meet either one of those, you simply declare all of your income and none of your estranged spouses. Now, here's the criteria. If you and your spouse lived apart the entire year. 2, you and your spouse didn't file a joint return for that year. You're thinking, well, that doesn't jive. What that really means is if they haven't beat you. If they didn't get to the post office box first and mail in a joint tax return, if you can beat them to the post office and file married filing separately or head of household under these sections, 504 or 555, then you meet the criteria. Continue on. You and your spouse had earned income for the calendar year that is community income. In other words, if you lived in one of the 9 community property states, such as Texas, and you and your spouse haven't transferred, directly or indirectly, any of the earned income in Condition 3 above between yourselves before the end of the year. And what that really means is, in a practical world, is you haven't commingled your income. So if you had a joint account and your money went in there and the other side's money went in there and it was all jumbled up, commingled, then you don't meet the requirement. But most people going through a divorce who've been estranged from their spouse for over a year haven't commingled the money. If you meet all those requirements and your CPA says that you've got to file married filing jointly and declare 1/2 of your income, I'm going to tell you to refer them back to IRS Publication 504 and 505, and that should end the problem. And that's a big area. I get calls on that every week. The next thing I want to talk about is IRS transcripts. If you're going through a divorce, the IRS transcript is so valuable. It tells you everything. It tells you so much. There are 4 types of IRS transcripts. The one that we really need to focus on is your account transcript. And understand before we go any further, an account transcript is different from a tax return. A tax return is prepared by you, an individual, or by a CPA, but it's created by you and remitted to the IRS. The tax transcript is an internal document that the IRS has created based on information they've received from you and from other third parties, like in our earlier example, the title company. So the IRS gets all this information from all sources, mortgage companies, title companies, et cetera, pension plan administrators, see all kinds of sources, and they combine all of this and they create your account transcript. And that's the actual document that we can look at to see what's really going on with you. Now, a tax return, of course, can be fabricated. So if the lawyer says, well, I'm going to get the tax return from the other side. I'm representing the wife. I'm going to get the tax return. I think it's in husband's possession. We get a subpoena out and we get that tax return and it says, well, he didn't make any money. Of course, he's the one that created that document. And I don't know if he actually submitted that to the IRS. I don't know if he actually filed that with the IRS. So we go directly to the IRS, get it from a third party, the IRS, so that we can verify the actual amounts that are on the transcripts. The two transcripts, I've already mentioned the account transcript, and also there's a wage and earnings transcript, okay? But between those, you can find out exactly what's transpired. Typically, you can find out how much money was made by who. Now, technically, to get a transcript in the IRS, it's only good for that one person, the one you represent, who's authorized you to communicate with the IRS. It's not going to show you, typically, how much the other side made individually. However, once you know how much your clients made, you can deduce from the other documents, if they filed married filing jointly, they've got a gross amount on there. That number you get from the IRS, you deduct your client's income, and that's the other side's income. But it's very important to get a transcript, especially in the middle of a divorce, for a lot of reasons, including those 941s, and et cetera, et cetera. You get a transcript for purposes of spousal maintenance or child support or division of the assets. The judge may doubt a lot of things. They may doubt a summary, et cetera. They may doubt verbal testimony, but they're not going to doubt an IRS transcript. Well, how do you get an IRS transcript? Well, there's 5 traditional ways. The IRS has created their own website just to facilitate getting transcripts. It's not just people, but businesses, LLCs, limited partnerships, nonprofits. There's one website that everybody goes to that's a portal to get copies of tax transcripts. It's irs.gov. They had to do this because they were so overwhelmed with people wanting copies of transcripts, people wanting information. irs.gov was created because if you think about it, it's going to be hard to believe, there are almost 1 billion tax returns filed with the IRS every year. There are 350 million people here in the United States. So that probably leads up to about 200 million tax returns. And every business in the United States has to file a tax return. Every small mom and pop, LLC, 500 corporation, et cetera, all have to file a tax return. Every trust, every philanthropy has to file a tax return. Well, the IRS was simply overwhelmed, and so they created this portal. Now, you can tell your client that they have to create an account with irs.gov, and kind of here's the mechanics. It's designed to be user-friendly. Of course, it's designed by the government to be user-friendly. But tell them before they sit down to create this account with irs.gov, they need a couple of things. First is they need a laptop with a camera on it. They need their Texas driver's license. They need their passport, if they have a passport. And it's best to create the account while they're at home. Now, the reason I suggest all those things is, number one, when you create an account at irs.gov, you have to have a camera. It's mandatory because that camera scans the face and does a facial recognition. Then the IRS wants to see state-issued ID. So, purposes of this conversation, this video, a Texas driver's license. The IRS can also request additional proof of ID. And the best is going to be a passport, but I've seen them request things like your mortgage statement. So that's why I suggest be at home when you create this account, because you may say, oh, excuse me just a minute, there's an IRS agent on the other side. Wait just a minute, let me go get that. That's in the kitchen drawer. You come back and you show them. You make a copy. You scan whatever it is they want. And that's why you need a laptop with a camera, your Texas driver's license, a passport, and do it at home. Once you have the irs.gov password and PIN number, etc., etc. It typically takes about 48 hours for them to create the account, and they give you the PIN number, etc. Then you come back in 48 hours and you log on. When you log on, you're going to have a lot of different options, but one of the options is going to be account transcript, and that's going to be the most important one. Now, if you're going through a divorce, or lawyer, if your client's going through a divorce, go ahead and tell them to open up all of them and print off all of them, the 4 transcripts. And you can do it for a lot of years. You can go back 5 or 6 years typically. So if you can go back 5 years and you get 4 types of transcripts for each year, you can get 20 transcripts. And from that, you can put together the pieces of the puzzle, and you've got some marvelous information. The next way to get an IRS transcript is the old-fashioned form, the form we used kind of before computers, 4506. Sometimes the old 4506T. That's when you have the client or the taxpayer sign it, and they authorize the release of information to a third party, and you attach money, and you remit it to the IRS, and you sit back and wait. That's the 4506 release. The next is the IRS Form 2848. Now, I give you this as information simply because it does qualify to get your tax transcripts. The problem is a 2848 can be executed by the client and given to the divorce lawyer, but sometimes the divorce lawyer doesn't have the capability to really use it. Most 2848 it's a traditional power of attorney, but to really use it, you have to be authorized by the IRS. If the IRS has issued you, the divorce lawyer, what we call a PTIN number or a CAF number, then you can use the 2848 and use that to extract the information from the IRS and get a world of information without really talking to the IRS or anything else. However, the absolute best usually is the IRS Form 8821. The 8821 is not a power of attorney. All it is an authorization for release of information. So you can have your client or the other side client execute an 8821 authorizing access information by the divorce lawyer. Now, sometimes you have to go through a hoop, and sometimes the divorce lawyer, it changes every day, no matter which IRS agent you talk to. That divorce lawyer may have to have his own CAF number or PTIN number, but the 8821 is typically the best way to get the information. And to really understand the difference between the 8821 and the 2848 is the 2848 is a traditional power of attorney to deal with the IRS and to negotiate with the IRS, to represent someone before the IRS, to make representations to the IRS about that person, etc., etc. The other form, the 8821, doesn't have any power at all. You're not empowering that person. You're not empowering the lawyer. You're enabling the lawyer to simply extract information. So therefore, the 8821 is the only one you want to give to the other side, but those are the two differences. So if you want the IRS transcript, you go through any of these things, and if that doesn't work, you can hire a law firm, and we'll do the old-fashioned power of attorney, and we can go to work and get that information for you. So we've covered the first 4 big areas of federal taxes and Texas divorces. The last issue, the last topic, is innocent spouse. Innocent spouse gets talked about a lot at seminars and, at the hairdresser and things like that. Innocent spouse is a unique remedy, an equitable remedy created by the IRS to help out people who have been wronged. And if you think about it, just the term, just the title, innocent spouse implies there must be a guilty spouse. So an innocent spouse, it's like trying another lawsuit. The divorce may be over, but it's us versus them all over again. We're good, they're bad. We're innocent, they're guilty. I'll tell you a few fine points about innocent spouse. Number 1, to even qualify for it, you have to file a joint income tax return. So people may have been married 20 years, but if they never filed a joint income tax return, then innocent spouse relief is not available to either one of them. Okay? Number two, you can do it in any state. A lot of people think it only applies in a community property state. No, any state. I've done them in a lot of states that were not community property states. If you get a tax notice and your former spouse's name is on there too, then the first thing you ought to think about is innocent spouse. Innocent spouse is a way the IRS realized in today's world. There are so many moving parts in relationships and marriages end. They end for a lot of different reasons. They also realize that not everybody knows everything that has happened in that marriage. People lead double lives. People lie. People hide and steal. And therefore, the IRS, after hearing all these stories from so many different people and kind of a pattern, they created something called innocent spouse. Innocent spouse, the classic example, innocent spouse is when you get a divorce. You have no idea that there's any tax problem. And in fact, on the date of divorce, there may not be a tax problem. You leave that relationship, and later, maybe 2 or 3 years later, you get the letter from the IRS that you owe these hundreds of thousands of dollars. You think, well, wait a minute. How could my client, how could we owe anything on date of divorce? We checked with the IRS and there was no debt owed. Well, the IRS can perform an audit at any time, or within a certain period of time after a tax year has ended. So if you got a divorce on December 31st, 2023, in 2025, you may get a letter from the IRS saying you owe hundreds of thousands of dollars because after you filed that December 31st, 2023 income tax return, and it was processed, and it was honored, and you've all gone separate ways, the IRS retains jurisdiction to do an audit. And if they do an audit, and they say, well, hundreds of thousands of dollars have owed, and it was a joint tax return, then you're on the hook. And the classic example is, like before, when they have a small business. And the small business gets audited, and that small business was what we call a pass-through entity, and all the income or loss from the business showed up on the individual tax returns of the parties. Okay? So let's say in our example, gender biased, husband ran a small business. And on paper, it lost money. But in reality, he was stealing from it. Okay? He was pocketing the profits. He was hiding them. He didn't deposit them. And so on paper, what he reported to the IRS was a loss. And so when they filed their personal income tax return, they did not owe any money. And they filed a joint income tax return. The IRS comes in later, after the divorce, does an audit and says, you've underreported income, you've lied, you've stolen, and therefore X amount of dollars is owed. They look at the first page of the original tax return. It was husband and wife, joint tax return. Therefore, that money is now owed 2 years after divorce by husband and wife because they filed a joint tax return together years ago. Client comes in your office with tears and said, how can I possibly owe this money? We didn't owe any money on date of divorce. We checked. Well, it's because of the audit, the jurisdiction, etc., etc. The way to deal with an innocent spouse case is if you have any indication that there may be tax problems in the future, then you've got to address it in the divorce, especially as a lawyer. And you can do it somewhat surreptitiously. But in your pleadings, you need to say certain indications and allegations that will help you later. Now, there are certain specific factors that the IRS takes into consideration when they make a decision whether to grant or deny innocent spouse. Some of these are statutory, and some are simply learned the hard way. I'm going to walk through these, and these are very important because we're going to take these and we're going to plug them back in our things like divorce pleadings and discovery, etc. Here are the factors that the IRS takes into consideration. And these are not in any particular order. They're all equally weighted. Economic hardship. So if your client is an hourly employee making $15 an hour and they get a bill for $400,000, It'd be an economic hardship for them to actually address that. Next, knowledge of income and taxes. The IRS specifically, I've had IRS agents come to my office and sit down with my client and ask, did you prepare these taxes? What did you know about these taxes? Did you help prepare these taxes? Did you gather up the receipts? Did you organize it in any fashion? And most of the time, in a lot of marriages and a lot of relationships, there's one person that handles the money. And if your client didn't help at all, then they're not going to be exonerated. But either they were deeply involved in the preparation of taxes, or classically, they didn't do anything. And the IRS knows that. And so if they didn't do anything, then they had no way of knowing. Yeah, they signed it and they're liable for it, but at least under the innocent spouse doctrine, that's a factor, an evidentiary issue that we can advance, saying, we didn't do these taxes. And in fact, in some cases, we weren't even allowed to see these taxes. And I do see that. The next issue is compliance. That's a word that the IRS loves to use. Compliance means that you have a history of complying with federal tax law. They look through their transcripts and they see how often did you timely file your returns? Did you timely pay the money that was owed, etc., etc.? Are you in compliance? A lot of people get this letter saying you owe hundreds of thousands of dollars, but they haven't filed their tax returns since the divorce. You cannot file a petition for innocent spouse unless you're compliant. And so the IRS will somewhat summarily deny your petition for innocent spouse if you never complied with the law. You're not filing your tax returns. Why should we give you any relief? So you've got to be compliant. Next, legal obligation to pay. Now, there's a lot of different ways of showing that, and there's a lot of different implications of legal obligation to pay. And the one that comes to everybody's mind first, and it's a forerunner, is whether or not the divorce decree allocates the obligation to pay, the legal obligation to pay. Now, it may say, if you represent the wife, it may say, husband shall pay. Now, that is indicative of a legal obligation to pay, but it's not binding. The reason it's not binding is because people could get a sham divorce and simply put in there that the other side pays all the taxes and this side gets all the assets. They leave the courthouse and they go live together under the same roof, but not married anymore. Well, for that reason, you can't just put in there that one side or the other pays all the taxes and that addresses the issue and it's binding. It's not binding on the IRS at all, but it is an evidentiary issue that helps you if it's in there. The next issue, benefits derived from income. And I see this all the time. People get a divorce, and you can look at the divorce decree and it tells you their life story. Because here's what the husband is awarded. He's awarded the hunting ranch, the dually pickup, the bass boat, all hunting equipment, 15 rifles, his trophy collection of all his elk heads from Colorado, the gold coin collection, etc., etc. Wife is awarded the house. Now, those things may be equal, but just from reading their divorce decree, a cold black and white document, you can sometimes get great insight to the life they lived and who really got the benefit of that income. And so therefore they look at who got the benefit of the income. Now, it could also be the flip side too. You know, some guys are somewhat enamored and they buy her diamonds and minks and Jaguar cars to drive and everything else, and that can sometimes be in a divorce decree, and she got the benefit of the income. They also look at the mental health. They look at the mental health of the parties at the time the taxes were prepared. So if someone had a mental health issue, odds are they're not going to read a document like an IRS tax return and really pick up on something's wrong. So therefore, if you can show any sort of mental health issues, that helps you in an IRS innocent spouse case. The next issue is physical health. I think, how can that be? Well, if you represent the wife and she was not in good physical health, she may have known that there was a problem with that tax return, but she's not going to speak up. She can't deal with it. She may be afraid of him. She's not physically strong enough to stand up to him. She's not physically strong enough to do anything. She may not be physically strong enough to look through the documents or call CPA. The next is adultery. Adultery is not just a taboo, not just a sin, but the IRS processes it this way. In our example, if a man is going to go out and commit adultery, odds are he's lying. He's lying about where he's spending his time, where he's spending his money. He's lying about his loyalty. He can be lying about every aspect of his life. And therefore, it's kind of a built-in, woven together. If he's lying about all that, he may have to cover his tracks and lie about his taxes, lie about his income. And the last issue, and this is the one that the IRS really, really focuses on today, is spousal abuse. We think of spousal abuse, man hitting a woman, and that does happen. But there's all kinds of abuse. There's physical abuse, emotional abuse, psychological abuse, sexual abuse. There's all kinds of abuse. And the reality is they look at is someone afraid. They're afraid to speak up. They know that tax return was bad. They know that their husband is lying. They know their husband's got money that he's not reporting on his income tax return, but they've been so abused that they've withered down and they're not going to cause a problem. And it can also be they're afraid because of what he might do to the children. I've seen that, and that comes up more often than you'd know. So these are the factors that help you win an innocent spouse case. And if you think about it, some of these we can help with our divorce pleadings and our divorce discovery. An example in our divorce pleadings, if there's abuse, we put it in there. If there's adultery, we put it in there. We make it public record. If you qualify for it, you can attach the affidavit that details all of the abuse, details whatever it is that it is, the adultery or whatever we want. And it's attached as an exhibit in the divorce petition that's filed a public record. Because when we file an innocent spouse petition with the IRS, we're going to attach that as an exhibit. We're going to show it to the IRS, and this is proof. And on the front page, it'll have the file mark of the district clerk or the county clerk where that divorce was pending. And it's kind of presumed to be accurate. No one's going to file an affidavit of public record, file marked with court, unless they can prove it or unless they believe it. So an innocent spouse deal, an innocent spouse relief can be huge. You know, a lot of times you can have an estate of, let's say, $500,000. But if you've got tax problems of $300,000, and you do the math, if we divide that 500 and one of them pays that 300, then literally one gets everything and the other side gets nothing. So these tax implications, these innocent spouse implications are huge. Many times, they're more important than the actual division in the courtroom. Because if you get whatever you get and then you end up paying these taxes, you get, or your client gets, or the other side gets, nothing. Now, to qualify for an innocent spouse petition, innocent spouse relief, you've got to meet the following legal requirements. You've got to file a joint income tax return. The joint income tax return has to be for a specific year, the specific tax year that's in question. Second, there's got to be an understatement of tax due to an error of the other spouse. Usually it's an understatement of income that leads to tax liability, but you have to prove it's the other spouse's fault. Third, you have to prove that the innocent spouse signed the return and did not know and had no reason to know of the understated tax liability. That's just a proof issue. And then when the IRS processes this, if you meet these legal requirements and you can show these evidentiary issues, then the IRS has the power to grant your client innocent spouse relief. I think I've probably done about as many innocent spouse petitions as anyone in the United States. And I'd like to tell you about my team that works with me on this. I have of counsel the retired regional director from the IRS of the Innocent Spouse Division. So when we interview a client about innocent spouse, he sits in, or he's there by Zoom, fills in the gaps. And he can usually tell us at the end of the initial interview whether or not we're going to get innocent spouse relief, whether it's going to be granted, etc., etc. But we filed this petition with the IRS. And we don't just file it with the general IRS. There's a special division just for our innocent spouse. And if they rule against us, then we can go to appeals. And if we lose there, we file a petition in the United States Federal Tax Court. So there's a lot of remedies we've got. If you qualify for innocent spouse, we take it to the top and we go all the way. Because if you've been wronged, you were wronged in the marriage, you were wronged in the divorce, we don't want you to be wronged after the divorce, dealing with the IRS about issues you may not have known anything about. Well, I've covered these big topics. I've been doing divorces for 40 years. I did my first divorce in 1984, 40 years ago. I've been licensed in tax court for 20 years. The dovetail experience between taxes and divorce is enormous. So many lawyers think they win the divorce and they walk out of there and their client has an overwhelming tax bill. And the reality is they haven't got anything. I hope this has helped you, and I love you. Next time. Bye-bye.